Good afternoon, ladies and gentlemen, and welcome to this Chamber webinar on enforcing contracts in India. Today's webinar is an initiative of the Chamber's very active Legal Services Interest Group, which is co-chaired by Dawn Tan and Tony Grundy. My thanks to them and to everyone involved in conceptualizing and delivering this webinar. In a moment, I will hand you over to Mr. Ashish Kabra from Nishith Desai Associates, who is the moderator for today's panel. Nishith, Ashish will introduce the panel. At any time during this webinar, please use the Q&A function in the toolbar at the bottom of your screen to type your questions. I will be back at the end of the webinar to make brief closing remarks. But for now, it's my pleasure to hand you over to Mr. Ashish Kabra. Ashish, over to you. Thank you.
Thank you, Victor. Thank you for the welcome. Very glad to be here, and a very warm welcome to everyone who has joined in for today's session. We hope we're going to make for an interesting one. The topic certainly is. I think this is something that affects everyone who does business in India or with an Indian party. This is an area which has traditionally been viewed as a challenge. We know that the government in India has been making concerted efforts to improve the ease of doing business in India, and enforcement of contracts is a key parameter for it. And in that, we have seen over the last, let's say, 5 to 7 years, a number of changes has been introduced, which has brought about a significant development in how the process currently takes place in India. Even though with all these changes, the improvement has not been at the level that the government or folks in India would have liked for it to be. But that is another aspect that we're going to look at and discuss today and see what we can do forward. So we have put together a stellar group of panelists, all very experienced in this space, who will share with us their views on what the developments have been, what is the lay of the land now, and sort of what can be done in the future. So without any further ado, let me just start with a brief introduction of all the panelists today. Firstly, Ms. Sheila Ahuja. Sheila, she is a partner in Alan Overy's Global International Arbitration Group and co-head of the firm's India Group. Then we have Mr. Akshay Kishore. Akshay is a partner in the dispute resolution team of Bird & Bird and is also part of their India Steering Committee. Thereafter, we have Ms. Shwetha Bidhuri. Shwetha is the head of South Asia at the Singapore International Arbitration Center, and she focuses on companies, investors, and legal practitioners in the region understand how they can effectively resolve international commercial disputes. And finally, we have Mr. Rohit Bhat. Rohit is a senior associate at FreshFields, part of the International Arbitration Group there. He has previously also worked with the Office of Attorney General of India, so clearly has tremendous experience in this space, and we look forward to sort of hearing all your views. A very warm welcome to all our panelists, and thank you firstly for joining in today. So a structure for the presentation was already given by Victor, so I'll skip that. I think we have covered all housekeeping matters to start with, and I'll go dive in straight into the discussion for today. And I'll start with Akshay. Akshay, we have seen a lot of developments taking place in India over the last 5 to 7 years. Obviously, the government, this is a key area for the government. So, and you undertaking so much work in this space or in line with Indian parties and this particular corridor, could you just give us an update on what these developments have been and what has the current status given these developments which have taken place in India? I think you're on mute.
Hello, everyone. A very good afternoon. Thank you, Ashish, for the invitation, firstly, and thanks to SICC for organizing this event. Yes, I mean, I think for the government of India over the past few years, rather the last decade, there has been a tremendous push, not only with the present government, but even the government before that, to project India as a business-friendly jurisdiction and improve its overall ease of doing business and in terms of improving the ranking for ease of doing business. Now, if you look at the World Bank's Ease of Doing Business Index in 2021, while India has improved on a lot of parameters, say, for example, resolving insolvency issues, from 108, India has moved to 52, between 2018 and 2019, and is keeping on improving. But it remains stagnant on enforcement of contracts. So that is a key area of concern as far as ease of doing business is concerned. And dispute lawyers and almost all of us here today are dispute lawyers, often experience that as the hurdle for international investors doing business in India. Now, historically, one of the issues with making enforcement of contracts becoming more difficult in India has been generally the complaint about slowness of getting judicial relief, the process through which cases go through in the Indian judicial process. Even the amendments of the 1996 or the introduction of the 96 Arbitration Act and the amendments to the arbitration legislation, enforcement of arbitration awards was always seen as a difficult and a slow process, moving ever so slowly through the courts in India. Although I must highlight here, if you look at the balance of the cases which were termed as being difficult, posing difficulty in enforcement of awards, of arbitration awards in India, were all passed in favor of foreign investors, or were actually the judgments were mostly in favor of foreign investors in those cases, even though they laid down the law, which made things a bit more difficult. Just moving on. So what have we seen in the last few years? We've seen some structural changes being brought about by the government in terms of ways in which you can seek relief or enforce contracts in India. One of the most important ones being with the introduction of the Commercial Courts Act in 2015 and establishing of commercial courts. The amendments to the Arbitration Act in 2015 to undo a lot that was done by the infamous Balco judgment, specifically in relation to obtaining urgent interim reliefs in support of arbitrations which were not seated in India but had some business relations with India. We've seen the amendments introduced to the Specific Relief Act in 2018, which is, I think, a marked change and a move away from a common law perspective to more a civil law approach of obtaining specific relief for enforcing contracts. And then obviously there is the new IBC code and the ever evolving role of the competition laws and the Competition Commission in India. But I think from a contractual perspective, the first three changes that I highlighted in the Commercial Courts Act, the Arbitration Act, and the Specific Relief Act, they play the most important and significant role. In terms of Commercial Courts Act, I think there are a few points to highlight, and I'm not going to take up most of the time here because I know there is a series of questions. I'm just going to move through a couple of highlight points between Commercial Courts Act, the Specific Relief Amendments, and the Arbitration Act amendments. Going to the Commercial Courts Act, the mandatory pre-institution of proceeding mediations before you institute proceedings, that has been helpful, and specific timelines provided for it for 3 months with a limited extension of time that can be granted. That has been that is a helpful move to encourage parties to settle the matters as quickly as possible before getting into protracted litigation. I think the changes that the Commercial Court Act has brought to the provisions of the Civil Procedure Code are quite significant, where especially in terms of costs. Now that becomes quite interesting because the Commercial Court Act provides that the parties can claim their costs and the losing party must pay. Under the CPC, obviously, the courts had a lot of discretion, and you would seldom in Indian courts ever get even 10% of the costs you incur in litigation. And now the judges actually have to record reasons if they deviate away from the principle of loser pays. So I haven't seen a lot of this yet, but at least the provision is there in the Act now. You have summary judgment provisions, you have amendments to timelines, disclosure, discovery, inspection of documents. You have issues which have been addressed regarding recognition of electronic records. presentation of written arguments, and now you have case management conferences like you have in Singaporean courts, right? So Commercial Court Act even introduces that amendment to the civil procedure. So all well-intentioned changes being brought about. However, as well-intentioned as these changes are, I think we're still far away from implementing them very effectively in India. You effectively have normal benches of the High Court being designated as benches of Commercial Court, and you don't have specialist judges. The volume of judges that you need appointed for Commercial Courts Act to be implemented effectively across the length and the breadth of the vastness of India. So you need more benches, you need more specifically designated judges. You can't just have existing High Court judges being designated as benches and rather increasing their caseload. So we're not addressing that issue. And I think there is a Judicial Reforms Committee that is looking into this, and we're hopeful that soon we'll have more specific commercial courts coming up. In relation to Specific Relief Act, I think a couple of points to highlight for our listeners today, that India, like most common law jurisdictions, specific relief was a discretionary remedy that the courts could grant where damages wouldn't be an adequate remedy. But the position has changed in India. So specific performance now is the default position, and it can be refused under limited grounds. There are 4, I believe, where a party has obtained substituted performance, contracts which involve performance of a continuous duty that the courts cannot supervise, contracts that are dependent on personal qualification of parties. So effectively, what you have under the Contract Act where you have contract for performance and not off performance. So you have one individual who's required to be entrenched in its performance and his qualifications matter. And last, that the contract is of a determinable nature. So obviously now this makes it more akin to civil law jurisdictions where specific performance is the first port of call. The Specific Relief Act amendment now also provides for substituted performance that parties, party which is at the receiving end of a default of a contract can seek. All it has to do is give a 30-day notice and seek a substituted performance from any third party. And it doesn't have to go through protracted court litigation to seek damages. Then it can simply say this is the quantification of damages for seeking substituted performance. So that's helpful. In terms of the last set of amendments in the Arbitration Act, I think, which I'd like to touch upon before handing it back to Ashish and the other panelists, is I think the Arbitration Act needed to undergo significant amendments post the Balco judgment. And I think it was needed that in Indian courts, which had, because of the judgment of the Supreme Court of India and Balco, who couldn't pass interim relief orders in support of internationally seated arbitrations, were allowed to do so again, and therefore that amendment came about. Obviously, there were amendments which are unique to India in terms of the interim relief, where in India you can seek an interim relief even after the award is produced, but before the enforcement. Which I personally have had the chance of being involved in a case like that in the Bombay High Court. It's very interesting that you can get interim measures of protection against the losing party pending enforcement of the award, which is very helpful, I think, in the Indian context, overall speaking. But I think the one point where the amendments missed the bus was enforcement of emergency awards, which are very recognized now in international arbitration institutions. But to a certain extent, the Supreme Court has come to the rescue of that in the Amazon versus Future case, and has paved the way for enforcement of emergency awards. So I'll leave it at that. There's a lot that has happened, and I think if we were to run through each of the changes, we need more than just 50 minutes to do that.
No, definitely. And I think you sort of because there are that number of changes, and you have very nicely sort of explained till now those many number of changes and very briefly as you could and succinctly as well. But Akshay, what you were focusing till now, and very rightly so, was on the legislative side of things and what are the changes that the government has introduced. But we also note that, and some of those you pointed out earlier, there's also been a movement or a shift in how the judiciary has been acting or dealing with matters over the course of last years. And let me bring in Shwetha over here. Shwetha, what's been your take of Indian judiciary or on Indian judiciary in terms of their approach towards enforcing contracts or dealing with, important commercial cases as we now see?
Hi, Ashish. Thank you, SICC, for having me here. And to your question, in terms of what the judiciary's approach has been, I would maybe focus more importantly in terms of the arbitration-related matters. So one of the reasons why there was strong criticism, if I may use that harsh word, against the whole system in India, with respect to international arbitration, was the enforcement of awards in India, and largely how the judiciary looked at the awards and the approach they took. And if I can say that this was sort of like now an archaic view that the Indian judiciary tended to be very interventionist in their approach. The tendency was to open up the award, look at how it's being dealt, to the extent of looking into the merits, how the interpretation of the contracts is being done by the arbitrators. And this was a huge setback, when you look at from the perspective of enforcement of contracts, because you're pretty much redoing the whole process. You fought through your case in arbitration, and now when you go to the court for enforcement of that award, you are re-agitating all of those issues, which is actually multiplying the time that it would have taken for you to enforce your contract, and of course the cost involved in that as well. But I think there has been a significant shift in the last, if I could say, 6-7 years. Of course, we've seen the amendments, in the 2015 Act, which was hugely welcomed, 2019, 2021. But more importantly, I think what we have taken notice of is the way, the judiciary has passed judgments strongly putting out there, what the policy in terms of, now here on, the Indian judiciary is going to be, which is clearly a signal that they intend to not interfere in the awards. And I was doing a quick search, looking at the awards that had come before the Supreme Court, particularly the foreign awards, and I couldn't come across a single foreign award that had been set aside by the Supreme Court under the 96 Act. I think there's one decision, but that's under the prior act. So there has been a strong shift, and of course a course correction, if I can use that word, of the way the Indian judiciary was looked at earlier, and now, even on the Indian side, where there were Indian seated arbitrations in domestic awards under Section 34, we had some notable judgments. Of course, the Sangyong came, and the Vedanta Limited, and where the court clearly said that our purpose is not to reappreciate the evidence or look at it as an appeal in that case. And I think these defining the contours of what the judiciary is going to look at is very, very important from the perspective of the enforcement of the contract. And of course, we also saw some important judgments where there were objections from the regulatory authorities when the matter came up for enforcement, where they said this is in violation to the Indian regulation, but the court did not really rejected those arguments and continued and proceeded to enforce the award. And those were interesting judgments, and I think those have been setting the new path, if I can say, for the enforcement of awards in India. But I must, maybe say a word of caution looking at some of the recent judgments, and particularly I think one which earlier in this year has come about with the Indian Oil case, where they have set aside an award. And it's interesting because they've gone on to make observations about the contractual interpretation by the arbitrators. So, we can't be going back and forth in this. And I think that's a caution that the court, I hope, continue to, the speed and the momentum that it had gained I hope that continues, from here on, and and we don't tinker with the awards as much. So while there has been a great improvement, I think we still waiting to see that consistency to remain in the coming years. So that's my 2 bits on.
Thank you. And interesting that you say the consistency is now what we are looking for. Another aspect which I really found interesting about Indian courts, and I think that would help, or that particularly helps with enforcement of contracts, was the adoption of technology during this whole phase of the pandemic, and possibly that court continuing with that use of that technology going forward. But we could not have imagined, at least back in 2019, that we could function that efficiently or have those hearings regularly. Even sitting here, we could appear back in India for those hearings. Something obviously wasn't expected. So that's definitely there. But yes, point well taken that there is this marked improvement, and we hope that there's consistency going on. But you also mentioned something about regulatory objections, and I think that's something that I would like to bring Sheila in now. Sheila, we see, and you are regularly working with foreign advisors, foreign investors who are on foreign players and business houses which are looking at India or operating in India or investing in India. For them, it is very critical that the basis or the premise that they enter those contracts with Indian parties with are upheld. But we have seen a spate of objections come in where parties, though they enter into contracts, subsequently rely upon regulatory objections to renege on their contractual obligations. What's your take on this particular issue that foreign investors are facing, particularly in Indian context? And what should be their take to ensure that the contractual bargains are enforced?
Thanks, Ashish. There's a lot to say in there, as there has been for the previous questions as well. But first of all, thank you to the SICC for organizing this, which I think is a very interesting topic, and one of those which is perpetually relevant. And also, of course, thanks, Ashish, for moderating and having us on here. I think your question on the interplay between the regulations in India and enforcement of India-related contracts brings into light some different angles. And as you rightly sort of foreshadowed in your introduction, I've done a lot of trying to enforce these bargains over the years. I think the upshot of the issue is that often what you find is that the parties will agree to a contract, and sitting next to the contract, maybe comfortably first, but then through evolution of these regulations, uncomfortably at some point, sits some kind of Indian regulation, Indian statute, which may cut across what the parties have bargained for. That then begs the question of, well, what does one do about that? Or how does one protect that risk? And when I first started doing these disputes some years ago, no longer count how many, we were looking at whether parties could agree a foreign governing law. So can you actually circumvent the choice of Indian law so that whole regime of Indian regulation and Indian statute can just sit on the side as you wanted to, and you can continue with the bargain, and there's certainty of enforcement of these contracts. Of course, that ran into a problem which the English courts sort of put down to a doctrine called the doctrine in Raleigh Brothers. It's a very old English case, but the doctrine applies not just India, of course, it's a widely known doctrine, where despite the party's choice of governing law, there may well be another law that applies as a result of the mandatory performance of the party's obligations in another jurisdiction. So what parties were arguing, and we saw this from, the 2008 global financial crisis in particular, I think revived Raleigh Brothers in a very big way, that despite choosing, say, English law, Hong Kong law, Singapore law, because these contracts had to be performed in India, or some part of them had to be performed in India necessarily, so it has to be a mandatory place of performance, you cannot avoid Indian law. And that was an argument that people had in principle, either as a preliminary phase or their whole case depended on this final question. And that then decided whether you open or shut the door to these regulations. So the first point was governing law, depends on where you are vis-a-vis Raleigh Brothers, depends on the mandatory point. The second question that came about that is the forum question. So could you agree a foreign seat or a foreign court? so as to circumvent an Indian court more likely than not applying these regulations, whether through Raleigh Brothers or otherwise. And I think that then led to, in particular in Asia, and I think India really led this, everybody agreeing arbitration with a foreign seat as soon as there was some question of some regulation potentially biting. And I did, for instance, a wave of these structured product disputes. And the issues there were really common, and they all came down to whether the Foreign Exchange Management Act, 1999 Statute of India, bit the transaction or not, and whether you could put that to one side or not. And of course, the problem with the structured product contracts in those days was that the real question, the qualitative question is, were those products genuine hedges or were they speculative? And actually, as a matter of contract, it doesn't matter, it's your bargain. But as a matter of Indian regulation, they had to be genuine hedges. So you would agree your hedge contracts or so-called structured product contracts, let's call it, anywhere. But as long as it touched India somehow, you'd suddenly have to make sure there were hedges. And this was the first wave that we saw. Lots of decisions came out of that, some in courts, some which didn't contribute to precedent because they were in arbitration. But to the extent that I was exposed to them, what I can say is that they were very mixed in terms of whether or not the tribunal took account of the Foreign Exchange Management Act. And more often than not, they would decide that there was no mandatory requirement to take into account the regulation. And so long as you chose an offshore forum, foreign governing law, you could actually see it through. But then the problem continued, and you did have some inconsistent decisions, to Shwetha's point about, did we ever sort of achieve consistency? And then we started seeing a wave of these put option type disputes where contracts for investment had an exit option, and the exit was on an assured return basis, or it gave you a value that was higher than the fair market value that the person exiting could get. And this started, I would say, maybe 5-6 years after the structured product. So we see a bit of a domino effect, and I guess it keeps us all on our toes. And again, there are FEMA-related regulations, which of course suggest that you can't do that. So then the question came to, can the Indian courts intervene, or does a foreign tribunal have to take that into account when deciding the issue? Now, intervention can happen either if the Indian courts decide to intervene as, as one of the competent courts during the arbitration or court process. But what was happening more was we were seeing enforcement issues being fought in the Indian courts. And the question there was then on, just to the point that Akshay spoke to, on prior to the 2015 amendments, how much could the Indian courts intervene as a matter of Indian public policy? Because in those days, any violation of an Indian regulation was seen as a patent illegality that fell within the definition of public policy as a blanket approach. But of course, post 2015, so that was sort of the crux of the problem, moving to where, how things moved along over the years. First of all, the Indian legislation was amended. So the Indian Arbitration and Conciliation Act went through, after I think decades of no amendment, we've suddenly seen lots of waves of amendments. The first of those was in 2015, which did narrow the meaning of public policy, particularly vis-a-vis international commercial arbitration and foreign seated contracts, so foreign seated awards. And so you can almost bucket that in that situation, you would expect, and again, to Shwetha's point on consistency, you would expect that an Indian court actually just has to live with what the original forum decides of the interplay between the regulation and the contract. And the Indian court should not look behind that. I think it's very different if you have a domestic award situation, because there they can unravel the contract. And I think their patent illegality and a wide meaning of public policy still exists and is still embraced. But whatever the question or however the depth of the inquiry, what really sort of came to light was that the judiciary needed to, or I guess legislation, or absent that, the judiciary needed to do something about this question of what does a violation of an Indian regulation do to a contract? So everybody was talking about, and I've seen so many different ways that the argument has been put, that once you have a breach of FEMA, that's it, there's no claim. Or once you have a breach of the Securities Contracts Regulation Act. But then there was the question of, does it really invalidate the underlying contract? Or is it just, there's a regulatory breach and you have a penalty, you get a slap on the wrist, but you still have an obligation to perform. And what we saw is, thankfully, clarity in a judgment of Vijay Karya some years ago, but not that long ago, actually, which held that transactions that violate FEMA shouldn't be held to be void. So actually, I think that's phenomenal, because until now, every tribunal was asking itself independently, does it invalidate the transaction? Or is it just that I'm going to encourage the parties to report a regulatory breach? Which I think, of course, should have been the case, from my lens. But this question is far from resolved until Vijay Karya. So Vijay Karya said transactions that violate FEMA cannot be held to be void. If a particular act violates any provision of FEMA or the rules under FEMA, so FEMA has lots of subsidiary rules that actually unhelpfully keep on evolving. So even if you agreed your bargain at a certain point in time, that may change by the time there's a dispute, or that may lead to a dispute as a result of a change. You can actually get permission from the RBI post facto to condone that violation. So there's potentially a parallel RBI process, the Reserve Bank of India process, that you can embark on to fix that, but it shouldn't affect your underlying contractual dispute. And that because such breaches under FEMA are rectifiable, they can't ever be held to be a violation of the fundamental policy of Indian law. And that, I think, wraps quite neatly the issue of, can you also raise it at the enforcement stage? Now, there have been court decisions prior to this that have found that, like Cruise City in Mauritius was Unitac was a very well-known one. And this sort of gives that, it validates those kinds of decisions. There was also an SRM expiration decision. So even where you have the RBI interplay and the RBI, I guess, approval is not forthcoming. The question is, does it still impact the validity of the transaction? And the answer is no. And so the question of who bears the consequences of then that violation is one that remains for contractual interpretation. So you almost find yourself asking a parallel question of what happens to that violation, but it does not affect your underlying contract. Now, to me, that's a lot of years of time, but getting to the right place. And so where we are now, I think, is a happy place. So I want to kind of freeze this point in time. But I would say, sort of to Shwetha's theme about keeping one eye on how things might develop going forward, there are other regulatory hurdles that we have seen. I mentioned the Securities Contracts Regulation Act. And that may used to be sort of describe a contract as a forward, a derivative, and it leads you to, again, all sorts of arguments under the SCRA. I've seen sort of disputes relating to stamping regulations that are used to prevent enforcement. And this, again, had a very domino effect because, one judgment comes out and, everybody realizes they may have a stamping issue as well. And the final point, so I hand back to you after this, Ashish, is that there's a doctrine of penalties which does suggest that there's a provision under the Indian Contract Act, Section 74, which allows only for recovery of sums representing a genuine pre-estimate of damage. So that basically is the doctrine of penalties coming into play. And we've seen other courts, England, Singapore, take sort of different measures on what that genuine pre-estimate rule should be and whether or not it should change. But India is still where it is. So again, that's one to watch out for. And sorry, I said that was my final point. This is my final point, which is that there is relevantly, I think SICC wouldn't mind if I take an extra minute to say that there's a recent SICC decision that actually was faced with an argument where the plaintiffs submitted that an arbitral award under the ICC was set aside or should be set aside for being in conflict with the public policy of Singapore because of this assured return problem, which they said violated FEMA and Indian law. And the SICC actually applied another decision of the Singapore Court of Appeal, concluding that it couldn't reopen those findings because they were findings of Indian law, which became findings of fact in Singapore, so they couldn't reopen them. But actually, they also, although they didn't decide the merits of this point of Indian law, they did also note that the tribunal's references to Cruise City, and there was entity Docomo as well, of course, made it clear that these were findings on the basis of Indian law and sort of almost sort of I guess, allowed them or approved of them, but without making an actual finding on the merits itself. So I would say, the SICC's view on this is very consistent with where we want to see things heading. Sorry, I will put myself on mute now, Ashish, and hand back to you.
Thank you. I think that was a very well explained position on how the objections in terms of FEMA at least have developed over years. But as you rightly pointed out, it took time for courts to get to the final answer in the right position. And the right position was also achieved by interpreting FEMA in particular in a certain manner, and so as to say that it doesn't result in the contract being annulled or being void if it's contrary to its provisions. Now, and you said that we now also see objections. You mentioned SCRA. We now see the future Amazon case where we have the objection of the contract being not, or the regulatory permissions required under the competition laws being put in abeyance. So we've seen certain hurdles arise, not just now from a perspective of FEMA, but also under other laws. Rohit, you obviously have a vast experience of practicing in India and now sitting outside India, but still working on India-related matters. How do you see, or what should a party do? Why it could be at the contracting stage, it could be later, because these objections are more and more becoming an issue for foreign investors and foreign players. And even otherwise, if generally you want to share what in your experience has worked when it comes to enforcing contracts in India, or what otherwise are the issues you face?
Thanks, Ashish, and thank you very much for the invite. Thanks, SICC, for the invite. I think everything that has come before me with respect to certainty or the fact that changing regulations are perpetually relevant are all things that we see in enforcing contracts in India. And maybe I can take this question by sharing experiences that I see when it comes to enforcing contracts from the perspective of a foreign investor, because we do a lot when it comes to international disputes. We see a lot of foreign investors try to tackle Indian regulations and the Indian judiciary and Indian legal system. And usually these contracts that foreign investors enter into will have arbitration clauses. So if I can first start with experiences in enforcing contracts through arbitration, it's never simple in India. There are multiple issues that do arise. So from a practical point of view, it matters where your dispute is. It matters who your counterparty is. It matters who the judge is, because all of these go to issues such as certainty that Shwetha raised and said is very important. And of course, it's extremely important, but whether you're going to have certainty in the manner in which contracts are enforced will depend a lot on all of these factors. And unfortunately, that is the reality. That's not necessarily a bad thing, because we have seen consistency in the past, despite all of these factors influencing enforcement of contracts. So just to give you an example, we have in the arbitration context in India, even if the arbitration is seated outside India, we always have the issue of Section 9, which Akshay raised at the beginning. Unless you exclude Section 9 from your contracts, and which I haven't seen most contracts do, you will end up in the Indian courts. And you will end up in the Indian courts before arbitration. And we see that a lot depends on whether the Indian court removes that case to arbitration or not, will depend on where that Section 9 is filed. If it's filed in Bombay or Delhi, invariably, you are likely to have it removed to arbitration. But if not, then you can get stuck in the Indian courts for a significant duration of time. Now, I say invariably Bombay and Delhi, you will have it removed to arbitration, but I am currently am advising on a case where the Section 9 has been in a court in these jurisdictions for nearly 2 years. So again, certainty is a relevant factor, and unfortunately, there is no certainty. And this is probably an odd case, but you see this odd one out situation where it becomes difficult for foreign investors to really understand, to factor in risk, which is very important for them, and and that factors into the price and cost of doing business in India. Now, in terms of set aside, someone mentioned Section 34. We have, of course, seen consistency in setting aside arbitration, domestic India-seated arbitration awards in India. But what is important is that the consistency that we've seen over the past 5 years continues for the next 5 years. And that, again, becomes judge-specific. So these are factors that play a huge role in enforcement of contracts. The other factor that we often see, and tying in regulation and where Sheila ended, which is assured returns and FEMA, what we often see is, especially in high profile cases, where there are public resources involved or where there are large Indian promoters involved, we often see investigations crop up during the dispute, which is quite difficult to handle. So, for instance, you mentioned competition laws and the Amazon Reliance dispute, where you have a competition commission permission granted to Amazon being revoked during the pendency of the dispute. But we also see a lot of Foreign Exchange Management Act investigations, maybe arising out of assured returns. We see sometimes prevention of money laundering investigations. We see also CBI inquiries. And this again goes to the question of certainty, right? Because eventually you may have the right result, but this impacts the way in which foreign investors factor in risk of doing business in India and enforcing contracts in India. So I think these are very important issues that they face, which we often see, based on my experience, I often see more regularly than not. Finally, I think there's also the question of enforcement of foreign awards in India. Again, like Shwetha said, that there are very few awards that are not enforced in India. Yes, that's true, but execution is very difficult. So foreign awards are enforced, but when it comes to taking money out of India, once the foreign awards are enforced, if the asset is located in India or the counterparty is located in India, it becomes extremely difficult to execute, because then you go back to execution procedures under the civil procedure law, which are cumbersome, time-consuming, archaic sometimes, despite some of the changes that have been brought about, including by the Commercial Courts Act. You also see regulatory issues when it comes to execution. So at the execution stage, sometimes you end up seeing tax issues. So is an award that is payable out of India to a foreign country taxable? There's the question of direct taxes. There's also the question of indirect taxes, which have cropped up recently. There's no certainty on that. I think, Ashish, you'll be better placed to talk about that. But GST issues on supply contracts, and when you pay damages arising out of supply contracts, are they subject to GST or not? There's absolutely no certainty. So I think these are the kind of issues that we often see. And if I can put all of this together, this leads to a whole maze that you have to navigate when you're dealing with an India dispute. Going back to the point that I first made, it's never simple. So you have to factor all of these in when entering into the contract. You have to factor in at the beginning whether you're going to push for, let's say, an exclusion of Section 9 proceedings in India to take away jurisdiction from the Indian court, which is now available to a foreign party, which wasn't available pre-2015. Or are you going to, and there are factors to consider even when you're thinking about excluding Section 9, for example, enforcement of emergency arbitrator awards. Are you going to do it through Section 9 or not? So it's very difficult. In terms of solutions, I think it's difficult to point to one solution. There are two support systems that are required. One is the law, and we have heard speakers say that there have been changes brought about to the law. Akshay spoke about the Commercial Courts Act. There was talk about the Arbitration Act. But the law needs to constantly respond to the situation on the ground. And we need a continuous string of positive changes. I think along with the amendments in 2015 and 2018 to the Arbitration Act, there have been some questionable amendments in 2021, which have taken the reforms made in the past. You've taken one step back, even though you've taken two steps forward. And with respect to judicial certainty, I think it's important to focus on judicial training when it comes to dealing with foreign disputes, because they're not dealt only in Bombay or in Delhi or in some of the other metro cities where judges have a more commercial bent of mind. They're also dealt in other cities where judges would perhaps not see too many foreign investors coming and litigating in those courts. So it's important from an investor point of view to have certainty overall, and that is difficult to achieve at this stage, I think. Let me just say a couple of other things before I stop. In terms of what would really help is something that Akshay mentioned at the beginning, which is allocation of costs and case management. Now, I know that the Commercial Courts Act has brought about these changes, but enforcement of these changes is a completely different story altogether. In my experience, I haven't seen Indian courts award the kind of costs that they should be awarding, which will then deter frivolous objections from being made. I also haven't seen case management conferences happen with the regularity that they should. Unfortunately, it is still the reality that you will have one hearing today and the next hearing in September, as happened on one of the cases that I'm involved in yesterday. So it's difficult, and you can't really blame the judges. There is so much backlog and there is so much pressure on the judges that it's impossible to have regular hearings. But an effort should be made, I think, in commercial cases. I'm conscious of the time, so let me pause there and hand it back to you, Ashish.
Thank you, Rohit. And I'm also conscious of time and the amount of other topics that we intended or planned on covering, and I doubt that we now can go through all, but at least let me do justice to what we are planning to cover to the extent we can. And on this one as well, very quickly, I just want to bring in Akshay and Sheila once again, because obviously you all also have had experience of enforcing contracts in India or against Indian parties or for Indian parties again in the region. Any quick points that you want to share on that, or any particular experience that you would want to share which worked or which did not work, whichever side?
Akshay, shall I go first very quickly and then hand over to you? Okay, so what worked and didn't work? I mean, what I would say is, depending on whether you are the party enforcing or resisting enforcement, maybe I can say one thing for each side. I think there's an overuse of the special leave petition provision. So if you're looking to enforce, sometimes you're met with too many, hurdles, court process hurdles. And there's actually a 2015 study which suggested that the number of special leave petitions vastly outranks the number of writ petitions. So you can imagine that so many decisions get thrown upwards. So at every stage, when you're trying to speed through enforcement, if you can, and even though there have been lots of reforms about trying to minimize the substantive scope of the grounds for refusal of enforcement to minimize the inquiry, actually the court procedure itself has so many stumbling blocks. And every time we get a favorable court order, you sort of half reach out for that bottle of champagne, and then you realize actually it's going to be flicked up to an SLP. So you just got a bigger proceeding to be faced with soon. So I think if you're trying to enforce, that's your biggest problem. How do you? I don't have any suggestions on how to navigate that, other than to say, please manage expectations if you've got clients who are trying to enforce awards. I think on the flip side, if you are trying to resist enforcement, what I would say is that the regime is not yet very clear. And so every regime, India is a New York Convention country, right? It's adopted Article 5 of the New York Convention, and so its grounds are what they are. But actually the Section 47 process of trying to get enforcement or recognition and enforcement is almost like a separate stage itself before you get to the Section 48 objections. And so if you're on the side that's trying to resist, you may not realize that the law has changed recently or it's still changing, I would say, on when you need to make your Section 48 objections. So if you're going through the Section 47 procedure and you have, say, maintainability objections, do you also need to put in your Section 48 substantive objections at the same time? There's been a lot of lack of clarity in that in recent decisions. So I think if you're resisting enforcement, you've got to be as clear as you can about the regime, so that you're not too late in trying to disrupt that process. So that's what I would say on the resisting enforcement side.
Sure.
Thank you. Sorry, for some reason I'm having a bit of connection issues. I keep losing voice. I don't.
Yeah, I think he explained that nicely and then got stuck over here. Probably we come back to you, Akshay. I hope this is.
You all can hear me. Highlight two in a negative note. On the positive note, Can you hear me, Ashish?
Yeah, no, Akshay, I think the line's not clear.
Okay.
So let me come back to you. Let's see if this works out.
Yeah.
Sure. I think also there's a question from one of our the audience who've joined in today. And it's addressed to you, Shwetha, and it sort of ties in what the discussion has been so far. And I'll put that up to you now, along with one of our own questions, that given what you have heard so far from everyone, is there any particular suggestion that you have for at least the audience members who have joined in today, or otherwise anyone considering to enforce contracts in India, that they could follow? And I'll queue that up along with what the question has come in from the audience for you. It says, what is the success rate of awards seated outside of India by foreign arbitral institutions? Example, seat in Singapore, the SIAC rules. Does having a seat outside of India or under a foreign arbitral institution carry any inherent risks in terms of enforcement?
So I'll take your question first and then the question from the audience. To your question in terms of what particular ways can the parties adopt, to sort of enhance the enforcement mechanism. So I think, I would probably ask the parties to go back to the basics, the starting point, when you have to look at resolving the dispute or enforcing the contract, is your drafting of the contract itself. And in that, particularly the dispute resolution clause that they draft. And it's important, I think it's no brainer to say that now at least majority of the contracts provide for arbitration as the means to resolve the dispute. Now, within that mechanism itself, whether you choose an ad hoc arbitration or the institutional arbitration will go a long way in the entire enforcement process, and particularly the time that it would take for you to enforce your contract. So I think it would be a wise choice for the parties to have an institutional mechanism in their dispute resolution clause, and also draft that clause quite tight, rather than having loose ends or having ambiguities or pathologies, as we term them, to ensure that you're not caught into the issue of the interpretation of the clause itself, and that's an important stage and a very, very, I think in terms of impacting the whole process is that crucial part of drafting of the arbitration agreement. Within the institution, choosing the institution rules, of course, the seat has an important role to play. While I would believe that a foreign party, an Indian party contract, they would ideally want to choose a neutral seat. So you may want to choose a seat which has a hands-off approach, to the arbitration process, doesn't end to interfere too much, or to, like we were discussing initially in terms of the judicial approach, to not get into the merits of the case, etc. To be able to uphold the award, the way it is, because the parties have chosen for that process to play out for resolving their dispute. So I think choosing that seat is a very, very important part of, of your, at the time of negotiation of your contract. Now to the question that has been put by the audience. Of course, at SIAC, we do not track the enforcement as such, after the award is delivered. But to an extent, of course, it is important from the institution's reputation itself, because if an award goes out, you don't really say it's this arbitrator or that arbitrator that gave the award. It's really the institution's name, So on our part, of course, the institution plays a very important role, an important step in the process, which is called the scrutiny of the award. And that step itself enhances the enforceability of the award. And this is to ensure that the concerns, particularly such as the due process concern. And, when you were discussing on the point before me where, Sheila and Akshay was sort of weighing in the points, and I think to Indian parties where Indian parties are involved in arbitration, I think an important point is also the conduct and the process in terms of the procedure. So we often discuss internally that how the Indian parties are just very proactive in terms of taking note of these issues if there are any, and that's why institutions' role becomes even more important to ensure there are no procedural, shortfalls. If they could at all be raised at a later stage, particularly at the enforcement stage. So the procedural history is set out well. Even issues like when the cost is awarded, whether it's a compounded interest, whatever. But all of these things are tightened in the award to minimize the scope, that a party can use to challenge the award or to question at the time of the enforceability. So, when you choose a foreign institution, the question is not really of a foreign or a domestic institution, but of an institution with a repute and experience. And I think the quality in terms of the case administration, that's what is important when you would choose. Again, a seat would be important because, and if I were to just simply talk about where you were to choose an India seat or a foreign seat, of course, a domestic award would get challenged under Section 34, where there is a wider ground in terms of, when you can open the award in terms of the patent illegality, etc. But where it's a foreign award that comes for enforcement in India, this is tighter. Sheila already mentioned the whole language of the public policy, to what extent can the courts go into. So while we don't track the enforcement process, anecdotally we've heard that the SIAC awards have been enforced in various jurisdictions, including India, and having a seat outside India or a foreign institution does not have any risk, so to speak, in that sense. In fact, like I said, you want to choose a seat which is pro arbitration and an institution which has the experience and has certain standing amongst the institutions themselves.
Thank you, Shwetha, for that. And I completely, again, agree in that sense that having a choice of arbitration, institutional arbitration, and then again seating it outside India is definitely helpful when it comes to eventual enforcement of contract and dispute scenario. On that, in fact, when it comes to enforcement of a foreign award in India, while that it depends, again, given the recent changes, who the counterparty is. For example, if the counterparty is a government entity, and it automatically becomes difficult to choose the seat outside India. And in fact, because of the circulars now applicable in two government entities, particularly in the infrastructure and public works sector, if you get a favorable award, 75% of that award amount nowadays is paid upfront to the upon furnishing the bank guarantee in court. So that way the recovery, even though the set-aside proceedings are ongoing, you can still recover. But yes, when it comes to foreign investors and their awards, a set-aside potential challenge which then comes up, and the whole set of proceedings of a 34 and thereafter an appeal under 37, and then a potential SLP, as Sheila was saying earlier, before the Supreme Court can be long drawn, which you definitely short circuit by going outside. But even on that, when it comes to enforcing a foreign award, we've seen that there are still certain challenges which we are hoping that the government will remove soon. Once the challenge is not really in terms of recognizing the award in India, but the step thereafter, which is actually executing, which is similar to any judgment as well. And we see that, for example, there's still the provision in India, if you want to sell immovable property, you have to beat a drum outside that property before it is sold to make an announcement the property is being auctioned. In today's day and age, having such a provision on your statute book is completely ridiculous. So things like this need to evolve. A decree needs to be transferred to the particular court where the asset is situated. The decree is still transferred by way of a registered post. So there is no need to do things such as this. Even you're moving a decree, it can be done online by email, as simple as that. So obviously there's a lot of scope for improvement, a lot of suggestions there. But I note that we have Akshay back. Akshay, we are over time now, but I do note that you were going to share something. So I'll probably give you some of the last comments over here in terms of what's your experience been, but I'll also cue in with one additional last question, which is the Singapore International Commercial Court, because we now are seeing some Indian party-related cases connected to arbitration as well, and arbitration seated in Singapore coming up there. What's your take on that, and could that also have a role going forward?
Yeah, thank you so much, Ashish, and apologize. I don't know, something went off all of a sudden on the internet line, so I'm having to dial in using my phone now. but something's better than nothing. So great to be back. But quickly speaking, let me start off on a positive note. You know, my co-panelists have spoken about issues with enforcement, but I can tell you, I mean, it's there's a judgment out there called Aircon Bibars versus Helico. From the Bombay High Court, which sets, in a way, it's not very widely reported, not very widely used. I was on the receiving end of that because I was representing an Indian party there. So where the High Court in Bombay, Justice Patel passed the initial order, had used Section 9, pending a challenge to enforcement, to give interim protection to the losing party to secure assets. Interim protection to the winning party to secure assets of the losing party. And this is the classic example where Section 9 in India, in the Indian Arbitration Act, goes a bit wider than the UNCITRAL model law and allows you to use interim reliefs even post an award but before enforcement. And that is a positive in terms of all the negativity around enforcement, you know, that you're looking at in India. In terms of negativity, there's, I mean, if you go to find one, then you'll find 1,000. I was involved in a matter where we went from far beyond in Jam Khambalia in Gujarat, very close to the desert, and we went all the way to the Supreme Court using SLP, where, as Sheila pointed out, where an arbitration in Singapore was stayed by a local court in far beyond in India, without any consideration for what the appropriate applicable law was. So you see a lot of this. In terms of SICC, I think it's an evolving process. I think another forum to support to support enforcement of arbitration proceedings. I mean, Sheila did speak about the latest CHY versus CIA judgment, where the court said that SICC struck down a challenge to an award, where it was challenged on the basis that it would be in breach of Indian law in terms of FEMA, and the SICC held that it was not a question of law, it was more a question of procedural issue in terms of it being referred to in Singapore and not in India. So that means SICC can play a greater role. It will play a greater role even in disputes being resolved directly rather than arbitration. But then the enforcement of SICC judgments still remains to be seen. India is not yet a part of. I mean, it'll be through the normal CPC procedure and not through the Rome Convention, because India has not yet ratified it, if I believe correctly. But I think more than that, Ashish, let me also highlight the role that the Singapore Convention is likely to play for enforcement of mediation directly. And while India has signed it and is yet to ratify, I think that's another glimmer of hope of international contracts getting an ease of enforcement, because mediation agreements would then also be enforceable directly. So I think that's another ray of hope for us for ease of enforcement in India. So I'll leave it with that.
No, definitely, thank you. And we hope that the convention is soon, and that notifications within India are passed on that very soon. And so last piece, and Rohit, with you, and probably we'll end there, is the Indian or the IFSC, or that is the gift city, or India's answer in that sense to Dubai, Singapore, New York, London, or their sort of more, or their replication of that particular regime or projection of it. So now, we heard recently during the budget announcements of the Finance Minister of India, Nirmala Sitharaman, mentioned that they are looking to set up an arbitration center in India. She had also mentioned about certain cross-border insolvency laws. But generally, what is your take on the IFSC, and would that in any help, or parties going there or thinking of that, does it have any impact on their choice of, dispute resolution? Would it lead to any ease of enforcement of contracts or not?
Yeah, so let's focus. Thanks, Ashish, and I'll be quick. Let's focus on the setting up of these institutions. I don't think setting up of institutions per se and setting up of multiple institutions should have an impact on better enforcement of contracts. I don't think you can make that leap In fact, what you need is one excellent institution which has the know-how to handle international disputes. And you can achieve that if all your disputes go to that one institution over a consistent period of time, and then you have that institution builds up that know-how. But I think setting up these institutions will help from a domestic point of view. And to your question, a lot of these arbitrations that you see foreign parties being involved in are also domestic arbitrations within India's seat. It could be because they are not allowed to choose a foreign seat. There's still that issue on whether two Indian parties can choose a foreign seat, even though it appears to be resolved now. But you see a lot of joint venture companies contracting with Indian companies, choosing India's seats. And I think in those contracts, it helps to have an option for institutional arbitration. So setting up of these arbitration institutions in various parts of the country, including in Gift City, will go a long way in building some sort of know-how in the domestic setup in order to resolve disputes. But I think just setting up the institution is not sufficient. It has to be combined with everything else that we spoke about, better enforcement of judicial enforcement of contracts and arbitration clauses, lesser interference, and consistency in judicial reforms and legal reforms by the legislature, I think. So I think there's still a long way to go. All of this is positive. It develops a bar, it develops an arbitration bar, it develops debate like we're having now on enforcement of contracts. And I think we will see the results over a period of time, but I think just setting that up is not sufficient.
I'm personally batting to say that while we make gift and offshore jurisdiction for other features such as the exchange control law, we should also do it for, let's say, arbitration. So any set-aside application would be subject to the test of refusal of foreign enforcement awards as opposed to the set-aside test. So that's what I'm hoping that they will do. But thank you, everyone. I think just to end on a more positive note, because obviously when you're talking about enforcement of contracts in India, it could get very dark very soon. But just to give some light at the end of the tunnel, we note that there are various other actions that the government is taking. Currently, there are 2 Niti Aayog task force committees which are constituted at the highest level, looking at the problem that Akshay you said earlier, adequate benches of the commercial courts, and B, the problem of government and foreign investor sort of interaction and the disputes between them and how to resolve those quickly. And we also recently, in January of this year, saw government sending a new guideline to all the public sector undertakings in India, asking them not to challenge arbitration awards unless they are very sure that their challenge would succeed. Or otherwise just take a call and to move forward. So there is some positive development. We do see that the government is taking some action to address some of the concerns that we had highlighted today. And obviously the situation is evolving, and we hope that the landscape going forward would be much improved in very near future. With that, I'll thank every one of our participants. I know that the number of you have stayed back beyond us, exceeding by a fair bit of the time that we had allocated for ourselves. I'll thank SICC for hosting us and for allowing all of us to come here and speak today. And with that, I'll hand it over to you, Victor.
Thank you very much, Ashish. So ladies and gentlemen, it's my pleasure to thank Ashish, Akshay, Sheila, Rohit, and Shwetha. And thank you for your company this afternoon. My team and I look forward to seeing you at the many upcoming chamber events and meetings. We're here to help you. So don't hesitate to write to herettohelp@sicc.com.sg with your requests and questions. For now, it's goodbye from me and all of us at Singapore International Chamber of Commerce. I wish each of you a good weekend ahead. Thank you and goodbye.